The push by the Trump administration away from climate regulation continues with the repeal of the endangerment finding. It's what led the EPA to take action to curb emissions on various pollutants, doing so under the Clean Air Act. But by making this determination, it may actually open the door to potentially a wave of public nuisance lawsuits against power plant owners. To discuss this, we're pleasure to be joined once again by Sarah Light, who's a professor of legal studies and business ethics here at the Wharton School. Sarah, great to catch up with you again. How are you?
I'm doing great, Dan. Thanks so much for inviting me today. I'm always happy to chat with you.
Thank you. What is it that the administration, I guess, let's start there, sees as a benefit by taking this action in the first place?
Great. So, in order to answer that question, if you'll permit me, I want to just give you a little bit of background about how the Clean Air Act works. So, the Clean Air Act, is a federal law that allows the government through the EPA to issue regulations to address air pollutants, largely from stationary sources of emissions like power plants or industry, as well as from mobile sources like vehicles, trucks, cars, SUVs. Certain pollutants were designated kind of early on, methane, carbon monoxide, nitrogen oxides, but the statute gives the administration some degree of flexibility to determine later on, with more scientific knowledge, that a different substance constitutes an air pollutant that endangers public health and welfare. And before the EPA is allowed to issue any regulations addressing that air pollutant, it must make what's called an endangerment finding. So back in the 2000s, under the Obama administration, the EPA issued this endangerment finding, concluding that greenhouse gas emissions, the 6 greenhouse gases under the Kyoto Protocol at the time, constituted air pollutants under the Clean Air Act that cause or contribute to air pollution that endangers public health and welfare. Okay, so the analogy that I like to give is, have you ever been in a hotel room? And when you go into the hotel room, you walk in and you try to turn on the lights and you can't turn on the lights. You have to put your key into a slot by the door.
Right.
And once you put your key into the slot, then you can turn the lights on.
Right.
Right. So the endangerment finding is the EPA putting its key in the slot that then allows it to issue regulations to address that air pollutant. So in 2009, the EPA issued the endangerment finding, lots of scientific evidence demonstrating this, harm to human health and the environment. And then subsequently, the EPA issued regulations to address greenhouse gas emissions from power plants, to address greenhouse gas emissions from motor vehicles. Okay, so I realize I'm going on for a while, but I hope this is helpful
No,
background.
yeah.
Feel
Yeah.
free to interrupt me at any time. So subsequently, the Obama administration issues greenhouse gas regulations for power plants and cars. Trump is elected. He leaves the endangerment finding in place, but issues weaker regulations for power plants and for cars.
Right.
Biden comes into power, stronger regulations for power plants and vehicles. And then Trump 2 comes in, and instead of just trying to repeal the regulations that the Biden administration adopted, they're going kind of for the nuclear option,
Right.
which is taking the key out of that slot by the door at the hotel. So if the endangerment finding repeal is upheld by the courts, that essentially deprives the EPA the ability to issue regulations. You can't turn on the lights, somewhere else in the room, if that makes sense. So so the Trump administration has taken a different approach this time. They are simultaneously attempting to repeal the regulations, turning off the lights, right? So they're taking both steps. If either one is successful, there will be a loss of regulation. But if the endangerment finding is gone, that basically means the EPA cannot issue greenhouse gas related limitations.
Right.
And I'll just mention one other thing. The way that the Trump administration has tried to repeal the endangerment finding is by focusing on motor vehicles and motor vehicle emissions.
Right.
But if it's
In part, probably
upheld,
because of the California standards, I would think.
In part because of the California standards, in part because of the potential for litigation
Yeah.
over power plant
Right.
emissions and things
Right.
like that. So, but that's, I think the analogy of the key in the hotel room is very helpful to understand. It's like without this, you can't turn on the regulations.
But it sounds like, and I don't know if this was intentional or not, but the one of the consequences is from your comments and the reporting about this is that this does open the door to potential legal challenges in the court system about what some of these electric companies and power plant owners are doing, correct?
That's right. So it's a little bit complicated, but I do think that it raises the possibility of significant additional litigation. So throughout this time period, when there's been pressure from environmental groups for the EPA to regulate greenhouse gas emissions and pressure from other groups not to regulate greenhouse gas emissions,
Yeah.
certain government entities like states, cities, the city of Hoboken, the state of, the city of X, they have brought tort litigation against power plants and other fossil fuel companies seeking damages, basically saying you have contributed to climate change. Our infrastructure is eroding. You profited, you owe us money. It's like any kind of standard tort litigation. You've done me wrong. I need compensation. Relatively
Right.
straightforward. Okay, so a case like this went up to the Supreme Court, and the Supreme Court basically said, look, the Clean Air Act allows for the regulation of greenhouse gas emissions nationwide as a system. And so we're not going to have these tort suits being brought by, the city of San Mateo, California, and the city of Hoboken piecemeal around the country and have
Right.
individual judges tell power plants, how much they need to pay or what they need to do. So basically, because there's this comprehensive statutory scheme, the Clean Air Act, which allows for the regulation of greenhouse gas emissions, we're not going to allow these tort cases to proceed, at least not under federal law.
Right.
After that, everyone try, it's like a game of whack-a-mole. So the entities that were trying to bring these suits started, okay, well, we'll bring them under state law. We'll bring them under California law, under Rhode
Yeah.
Island law, Massachusetts law, et cetera. And those cases have generally proceeded. And they are proceeding in the courts. There have not necessarily been judgments against the fossil fuel producers, but the fossil fuel producers are making the same argument. They've basically been saying, look, same deal under state law. The Clean Air Act allows for the regulation of greenhouse gas emissions on a nationwide scale. This shouldn't be a bunch of different state tort cases. And the courts are kind of divided a little bit on that. But if the Trump administration is now taking the position that the Clean Air Act does not cover greenhouse gas emissions, they are not an air pollutant under the Clean Air Act, then we're in a different universe with respect to these state tort cases because there is no
Right.
comprehensive federal statute that deals with this on a nationwide basis. And when there is no comprehensive nationwide federal statute dealing with a particular issue, often tort law, and in this case specifically nuisance law, comes in as a kind of background system to allow parties to address harms to them. So my view is that if you repeal the endangerment finding, you open up the potential for tort litigation.
Right. Right. And I guess, are we already starting to hear of organizations lining up potentially to prepare suits against these utility companies and power plant owners?
Well, so there are already suits in play. That's the thing. There are already there's literally litigation happening right now. And so, you know, we don't even need new additional suits to be filed to test this. But we'll see what happens, right? We'll see what happens.
What do you expect then to see? What will we see play out here potentially? And what sounds like it could be months and years ahead with with the litigation we're going to see.
Right. So I hope not years. I hope it's only months, but I do imagine that there will be, significant motions practice and filings in the courts as they make the determination about whether to uphold the repeal.
Right.
Initially, that decision is being made at the level of the Court of Appeals, but there's no question that whoever loses is going to take it to the Supreme Court.
Right.
Right. And
Exactly.
that certainly won't happen this term. The term ends in June. They've already, taken all the cases essentially that they're going to take this year. So that would be next year. And often the blockbuster cases are the ones that get decided at the end of the term. So we could be looking at a full year.
Then how similar then could potentially this kind of framework of litigation be to what we saw the Supreme Court rule on back in, I guess it was 2011, correct?
Yeah, absolutely right. Well, 2011 was Connecticut versus AEP, right? So that was the case where the state of Connecticut and other governments sued American Electric Power
Yeah.
under the federal common law of nuisance, and the Supreme Court said, too bad, so sad. The Supreme Court is considering a nuisance case in the coming term. That may end up being a vehicle, unclear. I can't totally predict what the timing is going to be, but that's the risk.
Right.
That's the risk, I think.
Sarah, always great to talk with you and get some insight on this. And we will stay in touch as this develops down the road. Thank you.
Stan.
You got it. Sarah Light, professor of legal studies and business ethics here at the Wharton School.